Hello guys, I'm Advocate Sanjay Arya from LEXIS and Company. On my previous video, I tell you the intellectual property registration and effect. And the second video, I disclose about the effect of non-registration in fingerprint. And third is effect of non-registration. So Primly and the infringements can only be brought upon the copyright registration. This due to the section 48 of the Copyrights Act, which states that the registration of Copyrights Act as a prima facie evidence of particularly entered therein. In the case you have registered copyrights and it is a being infringement upon you can be reported to the remedies under the chapters 12 of the Copyrights Act is provide for the civil remedies of injunction and damage, protection or separate rights, and the author especially right you can file a suit and initiative proceeding under the district court having jurisdiction over the nature. The patent registration a patent as a defined under the Patent Act 1970 means a patent for the invention granted under this act, and the inventions means a new product and process involving an inventive step and capable of industrial application. To apply for the patent, you needed to be either the investor, the assignment, or the legal representative of the inventor. Step to get a registration, ensuring uniqueness and novelty. The first step in the registration you are present is to be ensured that the product step in you can qualifies to be an invention. Moreover, it should not fall under the category, especially under the Section 3 of Patent Act. You can ensure the same by the conducting a patentability research. The second is the filing. The patent application is required to be filed with the patent office. The application must containing the title, preamble, full in the prior art solution and summary of the invention and their particular claim and example. The provision as well as a full application is required to be submitted. The patent application need to be submitted in several forums which containing details of the investor, specification of invention, technical information, declaration of inventorship statement, undertaking the other compliance documents, application, publication. Upon the filing of application, the India Patent officially after 18 months yearly, if requested, publish as an application in the patient journal, and a third point is verification. In the step, the application is examined and document are verified. If there is any objection by the examiner, the applicant must respond to those objections which are within a 6 months from the issuing of report of objection by the examiner, as the additional period of 3 months may be allotted for the submitting the response into such objection, and a fifth is granted. If all the compliance are made and objection are resolved, the patent office granted the patent registration to the applicant. And the publication, upon the granted of patent registration, it is published in the patent gadget by the Indian Patent Office. An effect of non-registrations, there can be no claim against any party for any infringement if the invention is not registered as a patent with the Indian Patent Office. In case you have a patent registered, you can find the someone in infringement upon the same. You can initiate proceeding under the district court where have judicial against the said judgment. And thank you so much guys. I hope you like it. हम आपके साथ जुड़ेंगे नई चीज़ों के साथ, नई बातों के साथ और नई तरीके से. And thank you so much.